welcome everybody who's joined us this morning. The session is going to be between three of us, myself, Stephen Flynn, Paul Gilroy KC and Tim Goodwin, and we're going to be looking at football and the potential impact that the Employment Rights Act 2025 is going to have on the game, particularly in England, but also in other jurisdictions within the United Kingdom. We're going to start with Tim providing an overview as to what the Act entails, and then we'll go on to discuss the practical impact. So Tim, if I can hand over to you.
Thanks, Steve. Good morning, everybody. It falls to me, as Steve said, to talk to you today about some of the key changes that are going to be implemented by the Employment Rights Act, insofar, of course, as they are expected to have an impact within the world of football. The Act received royal assent on the 18th of December 2025, and that followed a fairly, and I think rather unexpectedly tumultuous passage through Parliament. The biggest sticking point was essentially the substantial changes to unfair dismissal law, something that is going to have an impact on players, clubs and managers, and is going to be the focus of a lot of what we talk about this morning. Now, I'm conscious that many of you have lots of employment law knowledge and background. I'm also conscious that there are a lot of people attending this webinar this morning that don't know very much about employment law at all. So I think it's probably worth a quick rundown of what unfair dismissal is and what it's going to become. For those of you who are very familiar with this area, let me assure you this morning's webinar will not all be Employment Law 101, and please do bear with me. Unfair dismissal, as it currently stands, is the concept that an employee who has accrued sufficient service is entitled to be dismissed only in certain relatively limited circumstances, for relatively limited reasons, and in a proper manner. It is classically said of unfair dismissal that two things need to be established to render a dismissal fair: a fair reason and a fair process. Parliament decreed a limited list of fair reasons: misconduct, redundancy, capability, which includes both sickness and poor performance, illegality, for example, where someone doesn't have the required work visa, and then a bit of a catch-all to sweep up the rest, some other substantial reason. Once you have a fair reason, the employer then needs to conduct a fair process. What amounts to a fair process will depend on what the reason is. So for a misconduct dismissal, the employer will usually need to have conducted a proper investigation, a fair disciplinary hearing, probably an appeal. For a redundancy, it might involve a fair and open consultation about the reasons for the redundancy, a neutral and dispassionate objective scoring process, and to ensure that people have been selected for redundancy in an objective way. These elements of unfair dismissal law are not changing, but they are the backdrop for the parts that are. Employees who have been unfairly dismissed, or perhaps I should more accurately say those who consider they've been unfairly dismissed, can bring claims in the Employment Tribunal, and only the Employment Tribunal can hear those claims. The High Court, the civil courts cannot. Presently, that right to bring a claim is limited to those who have 2 years service. For a huge number of people, including, for example, a huge number of managers and players, that counts them out. They won't have the required service before their contract might end. Even if you can bring a claim, though, as an employee, the returns can be quite limited. At the moment, compensation is capped to the lesser of 52 weeks' pay, or 118,223. That's a number that has historically increased every year in line with inflation. So again, for high earners, it's seldom worth the investment, especially if you do the sensible thing of securing legal advice and representation throughout the claim, as legal costs are not recoverable in the Employment Tribunal. And the cap, in a sense, has also made things pretty easy to settle, and in some way reduced the burden of unfair dismissal, because employers could, and frequently did, simply dismiss employees and offer the maximum compensation under a settlement agreement, safe in the knowledge that unless a credible discrimination or whistleblowing claim can be manufactured, the employee will likely accept what's on the table, given there's little to be gained in terms of refusing and going to tribunal. So the combined effect of a long qualifying period and a relatively low cap on compensation meant that for many years, unfair dismissal rights were pretty limited. An ordinary unfair dismissal, so that is a claim for just unfair dismissal, was a claim that on its own did not have an awful lot of utility. But these are the things that are changing. Oh, forgive me, too far. So firstly, the qualifying period for unfair dismissal is coming down from 2 years to 6 months. And this is a change that is expected to come into force on the 1st of January 2027, so in just less than a year. What that means in practical terms is that everyone who is currently employed in a role, even if they only started this morning, will be protected from unfair dismissal from the 1st of January. Indeed, anyone that's hired before the end of June this year will have unfair dismissal protection come New Year's Day next year. It could have been worse, because the original proposal, indeed the proposal was set out in the Labour Party manifesto, was for day one unfair dismissal protection. So you would be protected from unfair dismissal the moment you started work. Now that was the major stumbling block in getting the Employment Rights Bill, as it then was, through the House of Lords. And the compromise that was eventually struck, because the Lords repeatedly sent it back having amended day one unfair dismissal protection to 6 months, the compromise that was eventually struck was that the compensation cap for such claims would be abolished, and abolished altogether. Now, this obviously massively changes the game when it comes to the value of unfair dismissal as a right and as a claim, especially for high earners. A claim that might previously have been worth relatively little, especially after legal costs, is now potentially unlimited. A slight caveat or note of caution I'd inject here, in terms of the abolition of the cap, is we don't yet know when this is coming into force. The government published a roadmap on the implementation of the Employment Rights Act in July last year, but that was before this compromise was reached, or indeed there was any suggestion of the cap on compensation being tinkered with. Furthermore, in the House of Lords, the final debate in the House of Lords on the bill, the government promised to consult on the abolition of the cap before implementation. Now, from my perspective, I think this is an issue that doesn't need much consultation. You either abolish the cap or you don't. So it sounds to me, if the government is talking about consultation, they may be open to creating some sort of hard or soft limit on what compensation is recoverable and how when the change is implemented. But I should stress that at the moment I'm speculating. If the Act were put into force as it is currently drafted and as it's currently been given royal assent to, it would abolish the cap on compensation altogether. Either way, though, it seems unlikely there's going to be a change to the compensatory regime in short order. Given the speed of consultations at the moment, I think it's unlikely there'll be any change this year. I think it's unlikely we'll see the implementation of this abolition of the cap or the raising of the cap before the 1st of January, when the qualifying period changes come in. But we'll have to wait and see. There are 3 other changes in the Act that I think are going to be relevant in this sphere and to this morning's talk. The first is that the limitation period for bringing tribunal claims, including unfair dismissal claims, is being increased from 3 months to 6 months because of the idiosyncrasies of early conciliation, which, for those of you unfamiliar with employment litigation, is a sort of mandatory pre-claim dispute resolution process. That will mean that claimants actually have up to 10 months or around 10 months to bring a claim from the point of dismissal. So it's quite a significant change. There's also the imposition of a new or a newish duty to take all reasonable steps to prevent harassment of employees by third parties. Now, this is harassment in the Equality Act 2010 sense, so it's discriminatory harassment rather than your common and garden harassment or harassment under the Prevention of Harassment Act. And again, for those of you less familiar with employment law, or indeed equality law, Section 26 of the Equality Act protects employees from being subject to unwanted conduct that is related to a protected characteristic, such as race or sex or disability, if that conduct has either the purpose or the effect of violating dignity or generating a hostile environment. Now, in theory, this new duty to prevent third-party harassment, I see absolutely no reason in principle why this would not apply, for instance, to players who receive racist or homophobic abuse from fans during a match. The new provision will impose a duty on clubs to have taken all reasonable steps to prevent that sort of abuse happening. And it makes no difference that it is being done by third parties. And finally, again, just in terms of, there's a lot more in the bill, but just in terms of what's relevant for today, there's a new restriction on non-disclosure agreements. Specifically, any clause of a contract that purports to prevent a worker from making any allegation of any form of discrimination will be void. So if you have a clause that for example, as is most common, a settlement agreement, that purports to prevent an employee, maybe a former footballer, a former player, or a former manager from raising allegations or from speaking publicly about discrimination they may have faced or they may have witnessed, that clause will be void. These sorts of clauses are extremely common in settlement agreements, and employers generally want to be able to protect their reputations. So I can see how this change may well have a deleterious effect on how easy it is to achieve settlement, because it may be that clubs are perhaps more willing to fight these sorts of claims and ensure that they can essentially clear their name by having findings in their favour. There are also two small caveats that I would flag in terms of this prohibition on non-disclosure agreements. The first is we don't have an implementation date. So again, it's not clear when it's going to come into force. And again, the language in the Act is, it might be pretty clear. It operates just to slot a new section into the existing Equality Act. So I don't really see any particular need to consult. So the fact that the government is going to consult before implementing this new regime does suggest to me that there may be tweaks to follow. The second caveat is that the legislation permits the Secretary of State to make regulations that effectively exclude the prohibition on these sorts of non-disclosure agreements in certain circumstances or in certain types of agreements. Now, we don't know yet what that is meant to be, what types of agreement the government envisages permitting this sort of non-disclosure agreement in. My suspicion, though, is we might see some sort of scheme whereby parties in disputes can agree some sort of non-disclosure agreement if various conditions are met. Now, you might say that would undermine the entire point of the ban on non-disclosure agreements, given that non-disclosure agreements are almost exclusively used in these sorts of settlement agreements. A cynical person might say the government would have the advantage of having been seen to do something about NDA abuse without upsetting any apple carts, but it's not for me to say. We will just have to wait to see how the consultation plays out and how it is implemented. So I'm going to hand over to Steve now. Steve, over to you.
Thank you, Tim, for that introduction. For my part, I'm going to be focusing on players and discussing the knock-on effects on these reforms on how we advise on recruitment, exits, disputes and risks in relation to players. Paul will then go on to discuss managers, where these reforms will have a related but distinct impact. So for a long time, football has operated in what I'd like to describe as a hybrid legal environment, in that statutory employment rights relating to dismissal have existed and implied in theory, but very rarely in practice. The sport tended to manage these tensions around dismissal through fixed-term contracts, which were ubiquitous, termination payments, and arbitration if there was disputes, as well as a thick layer of collective custom and practice where the different stakeholders had reached a consensus over many years as how things were dealt with for the most part. Now, the Employment Rights Act 2025 and the reforms that are going to come in, I think, may cause there to be a rebalance of that settlement. It's not that the case where these rights are new, they're not. It's more of a case where their application may become commercially unavoidable. So that's why we need to give some thought to them. And I say may become commercially unavoidable deliberately because the impact on football will really depend on how key groups respond to the changes. For example, we don't know currently what the players' tolerance for publicity of the Employment Tribunal claims would be, or whether unions and representative bodies would fund claims before the Employment Tribunal, or whether they're able to, given pre-existing collective agreements. And we also don't know how clubs will react to these claims. There seems to be a presumption out there that clubs will seek to avoid public confrontations with players at all costs, but in my view, that's too simplistic, and we'll come back to discuss that a little later. So just by way of introduction, my view is that the changes could have a seismic impact on football, but only time will tell. So the way I'm going to approach this is to highlight some of the potential impacts that I see. We're not going to have time today to bottom out in full repercussions, because that could be something that could go on all day, and I'd be happy to debate it all day. But if there's something that I've raised here this morning that you want to discuss further, then please feel free to drop me a line. So, Tim, if I could ask you to move on to the next slide, please. Tim's in charge of that. We'll start with the headline of what is most likely to change behaviour. And as Tim has said, that's in relation to the removal or potential removal of the compensatory cap. For most of us operating in the football sector and advising those operating in the football sector, the right to bring a claim for unfair dismissal was something that you mentioned as a possibility in advice or in a discussion and when advising a participant. But you almost always moved on because it didn't really make commercial sense to bring those claims, or there weren't really a commercial risk because of the relatively low value of them. But if the awards do become uncapped, then the arithmetic changes. Suddenly those claims are something worth thinking about if you're advising a player, because you could be looking at, in addition to lost earnings, career damage or reputational harm claims, and the impact of loss of a chance for future success. So the potential for significant claims, including future bonuses, become a lot stronger, and the avenues to recover those substantial damages will open up. That economic shift, in my view, will apply across the game, both to men and women's football, but also to senior and academy squads, which is obviously topical given the academy contracts introduced in the WSL last week. For example, a player who could currently be cleanly exited by paying up an easily quantifiable sum due under the contract will now have statutory claims that may have potential value or significant potential value that will need to be factored in. So, as I say, those representing players will have to consider a wide range of potential losses that could be sustained as a consequence of dismissal. And those advising clubs and club management will have to educate those making football decisions as to what this potential sea change could mean. For example, what is a practice in football of freezing out a player because the manager doesn't fancy them could now become a very expensive exercise if the player resigns and claims unfair constructive dismissal, which is something that we will have to consider and make people frontline football personnel aware of. So Tim, if I can ask you to move on to the next slide, and I should apologise to all those listening. I have a little bit of a sore throat this morning, so I'm breaking up a tad. The next driver, I think, behind change will be the issue of confidentiality or lack of it. So as Tim has touched upon, employment tribunals are public, with hearings, findings and judgments will be exposed to scrutiny. And that is particularly significant in this world because every piece of football news is reported and debated. And we also have the changes coming in with the independent football regulator. And if there's a judgment out there of an employment tribunal that exposes governance failures, you can imagine that will be of interest to the regulator. So these are practical considerations that we have to think into. In relation to players, they might not want their issues in relation to any dismissal to being debated in public, particularly if they relate to issues of attitude, capability or conduct, because that could harm long-term career progression. But other players might view it as a tactical leverage, believing that criticism of managers and senior executives will be an acute pressure point, which could result in higher settlements. Clubs may want to avoid reputational damage, but as Tim has already touched upon, others may believe that publicly rebutting unjust criticism is important. And we all know that there are more than a few owners out there who would welcome the limelight and have the opportunity in the public forum to put forward their own view as to how a player has treated a club. All parties will also have to give some serious thought as to the situation in relation to costs, with costs being the exception, not the rule in an employment tribunal. Some may be attracted to the extremely limited costs risks, might persuade them to bring a claim, whereas others will be very concerned about not recovering costs and being out of pocket. Again, as Tim has just mentioned, the possibility that the costs would have to be offset against any compensation received. And that leads to the position in terms of election, where a player will very early on have to give some thought, if they're dismissed for misconduct, for example, as to which forum they adopt. They can look to the internal football forum of player-related dispute commissions or the Contractual Disputes Tribunal in the women's game, or the Employment Tribunal. Tim, if I could ask you to move on to the next one, please. So this is an extract at the top of that page from clause 10.3 of the current Premier League standard contract, but the same wording is used in the EFL contract and the WSL contract. So if we have a situation where a player is dismissed, for example, for misconduct during the currency of their contract, they can appeal. And if under clause 10.3, they bring an appeal to a PRDC, the appeal has the effect of causing the contract to continue pending determination. So the practical effect of that and the attraction of that mechanism is that a player will continue to be paid. They might continue to be paid also, but if they've been dismissed for misconduct, I expect not, but they will certainly continue to be paid. So the PRDC has, if we call it that, has several advantages. Speed, you can get those arbitrations on relatively quickly. I've certainly got them on in a couple of weeks in cases. You'll be in front of a panel which has football-specific experience. The player will continue to be paid, and there's a possibility that they will order reinstatement. But the drawbacks, which might make the employment tribunal the more attractive option, is that they look at things through a narrow contractual lens, rather than the more holistic approach that the employment tribunal would embark upon when considering a claim for unfair dismissal. Whilst reinstatement is an option, the remedy for a PRDC is reinstatement rather than damages. So a player would have to decide whether they actually want to go back to the club. And they'd have to make that decision relatively quickly, because the time to bring an appeal under 10.3 is only 14 days. So if you are advising players, you will have to get on top of this very quickly and make a decision as to which route we go down. Now, just because you go before a football commission, a PRDC, that doesn't mean you can't bring an unfair dismissal claim. But if a specialist tribunal has found that the club was entitled to dismiss you, then it's going to have a significant impact on any claim and damages claim you will have before the employment tribunal. So this is a new situation that we're all going to have to grapple with. Now, when considering and discussing this, and some of you may have seen my LinkedIn messages about this, the question I was asked is, well, won't the arbitration clause in the standard contract still force parties into arbitration? Well, the answer to that, only my view, and I think it's generally the view of the three of us speaking here today, is the answer is no. The arbitration clause will be ineffective in terms of ousting the Employment Tribunal's jurisdiction for an unfair dismissal claim. That's because any contractual term purporting to oust the jurisdiction will be void unless the requirements of Section 203 of the Employment Rights Act 1996 are complied with. So that we will have this dual process of potential arbitration, potential employment tribunals existing. However, I can see a situation where players and clubs enter into settlement agreements after a dispute has arisen, where they confer jurisdiction to determine a claim for unfair dismissal to an arbitrator, bring it in within confidentiality and bringing it within a cost-bearing regime. There's nothing to stop them doing that after the dispute has arisen. But again, that's something as a tactical decision where both sides will have to decide what is the advantage or the drawbacks of deciding to put it into a statutory claim into a arbitration situation. Tim, can I ask you to move on to the next one, please? Another issue that I think we'll need to bottom out if this does all come through as planned, is how it will impact academies and young players. Now, we all know that way clubs operate is to identify all young players with potential and then filter them down to those who can play professional football. There's an issue as to when a player becomes an employee, and that's a whole session in itself, but for present purposes, if we look at a situation where a young player signs their first contract, that contract is for 1 year, which is very common in both the men's and women's game, with the hope of the club that they will progress to being a professional and a mainstay of the first team. But after spending a year playing for the under-21s, the club decides actually this is not going to work out. Now, currently, the club would let the contract expire and then let them go. But given the change from 2 years service to 6 months, they will have be entitled to statutory protection from unfair dismissal. And it's not hard to see a young footballer whose dream of playing in professional ranks has ended to trying to bring a claim arguing about the reason and the fairness of the dismissal. It could be said that it's capability, and then it will lead to issues around objectivity of assessment, warnings that were given, and opportunities that were provided to improve. So those who act for clubs will need to reinforce to those at the front line the importance of keeping records and to be able to explain the decision rationally if they're ever contested in an employment tribunal. And there's also the issue around release dates, which is the practice on the 30th of June of vast numbers of young players and even more experienced players being released at the end of their contracts. I can see there's a situation where there may be arguments about what the reason for dismissal was, with some arguing about whether it was a redundancy situation. And if there are more than 20 of them, the possibility that there's an obligation for collective consultation and awards being made because there was a failure to collectively consult. And that would particularly be the case in relation to clubs that are relegated. It's often the case when a club is relegated and it needs to cut costs, they identify the academy as easier than the first team. If there is academy players or young players who have attained employment status being cut, again, they might be asserting their statutory rights in relation to redundancy and collective consultation obligation. Tim, if I can ask you to move on to the next one, please. In talking of payments on termination, one of the interesting aspects is the effect that this will have on clause 19 of the Premier League and EFL standard contract. Now, for those who don't know, that provides that a termination payment will be made from a club to a player at the end of their contract when it expires, if no claim to the Employment Tribunal is made for unfair dismissal or redundancy. Now, termination payment is a month's pay, and as said there, capped at double the maximum compensation award that you can get before the tribunal. Now, if that abolition is effective, then there are going to be arguments as to what is the position in relation to the cap. I can see that there may be arguments that the termination payment clause in the contract is void for uncertainty, or alternatively, that the cap has gone and that there is no limit on what the termination payment could be. And that could be very expensive for clubs. So if we take the example last week that Casemiro is going to leave Manchester United at the end of this season, and the reports are true that he's earning £350,000 a week, the difference between the current double compensation reward, which would be £236,466, and the potential no cap of 1,520,000 is huge, and would make a significant difference to profit and sustainability calculations for clubs and things like that. So these are things that are going to have to be clarified. The slide there also mentions fixed-term contracts and how they're going to be dealt with. I know Paul is going to be discussing that, so I won't go into that in detail, other than to highlight that there is a possibility under the fixed-term contract regulations that a long-serving player could become a permanent employee, and you need to be alive to that. The final thing I'll touch upon is in relation to valuation. Now, the introduction of uncapped statutory claims could have a significant impact on the value of clubs when they're being sold, but also on the club's ability to refinance. Currently, when somebody's coming to buy a club or somebody's looking to lend money to a club, they can work out what the worst case scenario is if they had to pay up all the contracts, or there's a liquidated damages clause in relation to managers. Well, if that's uncapped, then these are significant claims that could potentially be brought against a club. You can see a buyer reviewing employment policies before a sale is completed. They're wanting warranties and indemnities in a different way than they've had previously. And there will also possibly be purchase price adjustments for if claims do come down the track, and to try and recover damages that have been paid. But also if there are claims that are from before the Employment Tribunal, and because of their uncapped nature, they would have to be recorded in accounts, and they would have to be regarded for solvency and going concern assessments. So if a club is seeking to refinance, people will be looking at that and having concerns about that, and it may make it more difficult to raise funds. And that's obviously a significant concern at League One and League Two level in the men's game and in the women's game also. So to conclude in relation to players, my view is that this will introduce a period of real uncertainty to an area that has historically prioritised predictability, but the impact will only be clear once we see how players, clubs, unions, tribunals and regulators all respond in practice. But I think it's a fair assumption to say that things are going to change. And as I said, I have a lot to say on this subject, so if anybody does want to speak about it further offline, then please drop me a line and I'll happily discuss it with you. But for now, I'll hand over to Paul, who can discuss managers.
Thanks, Steve. Good morning, all. If Tim could put the next slide up, please. So I'm going to speak very briefly about the implications of this new law for football managers. There's quite a degree, obviously, of overlap between, in particular, managers and players, but there are certain particular aspects that are of great interest as far as the managers are concerned. So you've heard already about the removal of the cap. The cap on compensation for unfair dismissal has always been arbitrary. I think many years ago it was down about £8,000, and it went up incrementally over the years until we now have an annual uprating, the present figure being 118,000 in terms of the compensatory award, or a 52-week pay cap, whichever is the lower. The impetus has always been on the restriction and the limitation of employees' rights and employees' claims as far as financial relief is concerned. And in 1992, the UK, as a result of a case called Marshall, was effectively dragged kicking and screaming by the European courts into accepting European law that determined there should be no cap on compensation for discrimination claims. So we have this strange dichotomy that in the Employment Tribunal, we have the cap for unfair dismissal, we have no cap for discrimination, and we also have a situation where there is no cap if you are automatically unfairly dismissed because you are a whistleblower. And that obviously is a matter that's been driven by public policy. The net effect of that is that every claimant's employment lawyer, when faced with a new client on a termination, the first two questions are, Do you think you've been discriminated against, or do you think you're a whistleblower? Because of the implications of the answers to those two questions. All of that is going to go away if we have the implementation of these changes. And I say if, because the phrase, I'll believe it when I see it, perhaps springs to mind. When you look at the history of the passing of the legislation and you factor in certain other factors such as the political battle that has already been waged about bringing these rights in, to mention the amendments in the House of Lords. Add to that dimension the political angle, which is the trade unions pressing the current administration to make sure they bring in all of the rights they said they were going to bring in, and whisper it quietly in these very delicate political times, the security of tenure of the current administration. If we've got an implementation date of the 1st of January 2027, a year's a long time in politics, but that's perhaps subject of an entirely different webinar. The manager will now find unfair dismissal to be a worthwhile claim. The present situation is that in, if you forgive the expression, a normal sacking, which is a face doesn't fit, or the club no longer thinks you're the person to take the club forward type sacking, the manager in the Premier League and the Championship would have no interest in the Employment Tribunal because of this financial ceiling. But now that we have potentially this removal of the cap, potentially the sky is the limit, and therefore the choice of venue for the manager becomes much more wide open, because he or she indeed has the opportunity of taking a claim to an extra football, extraneous to football body, a judicial body, to determine rights. And you hear football managers and clubs saying, the person's been sacked, what's the value of the contract? Well, yes, what is the value of the contract? But we also have to look now at the question of what the value of the claim for unfair dismissal is, because it is a statutory claim and it is not a contractual measure of compensation. It is what is just and equitable to awarding compensation by reason of the unfair dismissal. It's a different test, a lot of overlap, but a different test. There are cases, and one of my pet subjects is, there are cases where you can carve out for a claimant a claim for a full compensatory award under the current constraints, plus get your contractual damages. So these are all considerations which come into play. The non-renewal of a fixed term contract, that's always been dismissal, but the new dimension is, with the removal of the cap, the clubs are going to be much more careful, have to be much more careful about the reasons for getting rid of a manager. One of the biggies for me, as far as managers are concerned, is the next bullet point and the sub bullet points, which is the removal or reduction in the requirement of 2 years continuous service. It was said it was going to be day one rights. We currently have the compromise of 6 months. But if you look at that list of names there on the bullet points, that's a snapshot of this season, 6 Premier League managers. So an attrition rate in just over half a season of approaching 1/3 of the manager cohort. And if you look in particular at Ange Postecoglou, 39 days tenure. You have Russell Martin, and obviously north of the border, 17 games. Wilfred Nancy, again above the border, 33 days. Now, those at the absolute extreme end, obviously if it's 6 months, that's not going to help them. But just imagine the number of managers who will now fall into the catchment zone if this goes down from continuous service of 2 years to 6 months. So bringing that all together, I say much greater job security, because the things that clubs care about most of all in that sacking situation are the financial implications. Obviously, reputation is important, particularly at the top end of the Premier League, but it's got to be said that if this all goes through, managers will have greater job security. Could I please have the next slide, Tim? So, drawing this together, what do we have? Financial risk becomes much more unpredictable. The position of the club when making its risk assessment as to what to do, it's going to have to contemplate a sliding scale of 0 to potentially, in certain circumstances, £10 million if it's uncapped compensation in the Employment Tribunal. And also, this depends on the interplay between arbitration and unfair dismissal, which I'll touch upon very shortly. We have, I would say, a shift in the power dynamic from the club to manager, inevitably. The Employment Rights Act clues in the title. And if a claim is made, it's no longer an option for a club to admit liability to protect reputation, because what a club could do, faced with a high-profile manager being sacked, is make an admission, offer to pay the full amount. You turn up at the Employment Tribunal and the employment judge says to the manager, what do you want me to do? It's already been sorted, and the club keeps the lid on the publicity that would otherwise be given to the case. Now, I can tell you there are Premier League arbitration tribunal managers cases where if they were not held in private, and they are held in private, if they were not, as they're running their course, they'll be on the back pages of the newspapers on a running basis throughout the entirety of the hearing of that particular case. Greater bargaining power for the manager in terms of settlement, for example, confidentiality. Again, we've got the tribunal in public. Very difficult to get confidentiality in the Employment Tribunal. Restricted reporting is very much against the current way of thinking, which is open justice. If you want to make an application to keep things private, it's notoriously difficult to do that, whereas there is a complete cloak of secrecy as far as arbitration is concerned. And I've been amazed over the years at the fact that there is very little leakage from the private arbitration sphere into the press about what actually happens behind closed doors in these arbitration cases. Much greater emphasis on decision making, less firing from the hip, completely alien, previously alien performance processes for football managers. If the club wishes to protect its position, having to audit the discussions it's had with the manager about benchmarks for performance. What are the expectations of the club? Is it final league position? Is it progress in a cup competition? Is it top 4? Whatever it is, tribunals will expect, in a way that football fans might feel is quite artificial, to have this audited and set down in writing so it can be gone back to when there is a claim and it can be said, look, these things were addressed on a timely basis. These are the standards and you failed to meet those standards. I strongly suspect that notwithstanding the need for these things, it will be the exception rather than the rule where such processes will be brought in. Steve's mentioned the Football Governance Act that has implications in terms of clubs being found by a public body such as a tribunal to have governance in issues. So early decisions required on strategy if the club doesn't want to suffer a major fail at the Employment Tribunal. Please could I have the next slide, Tim? So jurisdiction in the Premier League, and I've literally simply quoted the clause there. What does that mean? There's a compulsory clause in the manager's contract that the dispute in relation to his contract shall be determined by the manager's arbitration tribunal. Focus on those words. A dispute arising between the parties to a manager's contract of employment. Nothing to do necessarily with the question of unfairness or the statutory claim of unfairness. This is the sphere of breach of contract. It is the sphere of wrongful dismissal as opposed to unfair dismissal. And it is the contract which is the focus of the Managers' Arbitration Tribunal when it deals with these disputes. You can bring parallel claims, and to protect your position, you have to do it fairly quickly in the tribunal. An example of that, and it's a matter of public record, was the Antonio Conte in Chelsea, a full Premier League Managers' Arbitration Tribunal hearing, plus an Employment Tribunal hearing. So you are not blocked out. You do not have to elect. You can still have both. But note the difference between the jurisdiction. Really, the MAT deals with the contract, the employment deals with statute. As Stephen has said, you can't oust the jurisdiction of the Employment Tribunal. Section 203 of the Employment Rights Act prevents that. 3 quick practical issues. You're going to have much more of a forum battle. For example, does the tribunal go before the arbitration? Does the tribunal go before the High Court? The tribunal is going to have much more say in saying, well, just a second, this thing could all be resolved in the tribunal because we now have no cap on compensation, and therefore we're going to deal with it. Next practical issue, the backlog, the current tribunal backlog is definitely a factor that one is going to have to consider. The backlog is presently pretty horrendous, but it's going to get a lot worse with the removal of the cap and the reduction in the continuous service requirement. So it's going to be a double nightmare. I heard this week of a case being listed for 3 days in a tribunal in England where it's been fixed for 2029. When the Employment Tribunal was brought in as the Industrial Tribunal, it was said to be the forum for the quick resolution of employment disputes. That description sits rather uncomfortably with the present situation we have. And the third angle, I've mentioned it already, is the political one. Will we actually see these things being brought through, given we have to wait until January 2027 for the main ones? Last slide, please, Tim, if you would be so kind. I've simply done the same thing for Rule K as I have for the Managers' Arbitration Tribunal. Slightly different position here. The wording here is any dispute or difference between any 2 or more participants, and it is an inclusive set of bullet points. It's not stating what the full panoply of rights are available under Rule K, but Rule K has never been and will never be, I would suggest, the forum for the determination of an unfair dismissal claim, which has to be dealt with under Section 98 of the Employment Rights Act, and it has to be dealt with by the specialist tribunal which has been set up to deal with those claims, which is the Employment Tribunal. So that completes my whistle-stop tour of the points that immediately occur to me as far as the implications of the new law and managers are concerned.